What if one Supreme Court ruling rewrites how every high school and college assigns a jersey, a locker, or a starting lineup? On the 13th of January 2026, the court heard two consolidated cases, little v, Hecox from Idaho and West Virginia v. B.P.J. that could decide whether states can bar transgender girls from girls' sports, and that decision could ripple into locker rooms, Title IX enforcement, and even school dress codes. Stick with me. I'll break down the likely holdings, immediate effects on school policies, and a practical 7-step checklist school lawyers will use to avoid litigation. By the end of this narration, you'll understand the two legal questions the court is answering, the doctrinal options the justices are weighing from Title IX interpretation to the level of constitutional scrutiny, and 3 concrete steps students, parents, and school attorneys should take the day the opinion drops. This is educational content only, not legal advice. Laws and court rulings change, so consult a licensed attorney for specific guidance. Little v. Hecox and West Virginia v. B.P.J. were consolidated for argument on the 13th of January 2026. At their heart, there are 2 big legal questions. First, does Title IX's ban on discrimination on the basis of sex protect transgender students, meaning is excluding a transgender girl from a girls' team unlawful sex discrimination? Second, what level of scrutiny does the Equal Protection Clause demand when government action singles out transgender people, ordinary rational basis, intermediate scrutiny like in United States v. Virginia, or even strict scrutiny? Why does that matter for schools? Because the answers determine whether state laws like Idaho's or West Virginia's statutory bans are permissible. A ruling for Idaho and West Virginia would likely greenlight similar state laws and let schools maintain exclusionary policies. A ruling for the students could force states and districts to change eligibility rules and prompt new federal enforcement under Title IX. The stakes are immediate and practical, not just theoretical. The court could also decide nothing big at all if it finds the case is moot on procedural grounds. That would leave lower court rulings in place and keep uncertainty high. Title IX says no person shall be excluded from participation on the basis of sex in any education program receiving federal funds. The interpretive fight asks whether sex includes gender identity. Some advocates point to Bostock v. Clayton County from 2020, where the court held that firing someone for being transgender violates Title VII. Could that logic carry over to Title IX? Maybe, but statutes differ and context matters. If the court holds Title IX does include gender identity, federal protections would likely cover transgender students in many school settings, including athletics. That would empower the Department of Education to enforce non-discrimination rules and could invalidate state bans that conflict with Title IX where federal funding is implicated. If the court holds Title IX does not reach gender identity, that gives states more room to impose exclusionary athletics policies without running afoul of federal statute, assuming no other federal law applies. Which way will the court go? Follow Bostock's textualism or treat Title IX as a distinct statutory scheme for single-sex programs? The answer will ripple into school handbooks, tryout forms, and eligibility checklists. Equal protection review determines how hard the government must justify a law that classifies people. If classifications based on transgender status or sex plus gender identity trigger heightened scrutiny, then states must show the law substantially advances an important government interest, or under strict scrutiny, that the law is narrowly tailored to a compelling interest. If only rational basis review applies, courts will uphold laws as long as they are rationally related to any conceivable government interest. The court could find that laws singling out transgender people are sex-based classifications and therefore get intermediate scrutiny under the line of cases like United States v. Virginia. Alternatively, the court could carve out a new category or treat these statutes differently. And some justices may be skeptical of expanding protected categories. The practical takeaway? If the court applies heightened scrutiny, many state bans may fail unless they can produce strong evidence that excluding transgender girls is necessary for safety or fairness in female sports. If rational basis applies, bans are much more likely to survive. But even if the court applies heightened scrutiny, it could still uphold narrow exclusions for competitive fairness. So heightened scrutiny is not an automatic win. The devil is in the tailoring and the evidence. Lawyers and scholars are mapping 4 plausible doctrinal outcomes. 1. The court rules Title IX does not cover gender identity and applies rational basis review to equal protection challenges. The result? Many state bans upheld and schools gain latitude to bar transgender girls from girls' teams. 2. The court rules Title IX covers gender identity and applies heightened scrutiny. The result? States must meet a high bar to justify exclusions, and many existing bans could be struck. 3. The court finds a middle ground. Gender identity discrimination is covered by equal protection but allows narrowly tailored sex-segregated rules under strict evidentiary requirements. The result? Schools can preserve some sex-separated competition, but must base policies on clear, evidence-based criteria. 4. The court decides the cases on procedural grounds like mootness or standing, leaving the lower court patchwork intact with limited national precedent. Predicting the court's coalition is hard, so schools should prepare for all 4. Each outcome demands different operational responses, from updating handbooks to defending statutes in state court. Day 1 after a ruling, superintendents and athletic directors will be asking, do we pause tryouts? Do we change roster rules? Expect a flurry of administrative adjustments. If the court upholds bans, school districts in states without such statutes may still face pressure to adopt more restrictive rules from parents or local lawmakers. Expect more states to pass or refine statutes. Reporting suggests roughly 27 to 29 states have enacted restrictions of some kind, so many districts already operate under state constraints. If the court strikes bans or construes Title IX to protect gender identity, districts receiving federal funds will need quick legal counsel to revise tryout forms, eligibility criteria, and facility access rules to avoid federal liability. Locker room assignments, privacy protocols, and record keeping, like how a student's records reflect gender identity, will become frontline compliance issues. Eligibility criteria that use hormone levels, transition timing, or competitive categorization are likely to become focal points. Schools will need defensible standards backed by medical or sports performance evidence if they intend to maintain any restrictions. The ruling will not magically resolve every privacy or safety complaint. Expect separate litigation and guidance on physical facilities. Lower courts and state legislatures will react predictably. If the Supreme Court upholds bans, state legislatures that haven't passed laws may do so quickly. If the court rules for the students, many states with bans will see emergency filings and potentially new, narrower statutes aimed at surviving the court's test. Lower courts will parse the opinion's scope carefully. If the Supreme Court issues broad doctrinal reasoning about sex and gender identity, lower courts will apply that logic to bathrooms, single-sex scholarships, and extracurriculars. If the ruling is narrow or procedural, litigation will proliferate as parties seek a ruling with nationwide precedential weight. Expect the Department of Education to jump into the fray depending on the ruling. A decision that Title IX covers gender identity would likely prompt renewed federal guidance and enforcement actions. Conversely, a rejection could weaken federal leverage and increase state autonomy. How fast will state legislatures act? Quickly. Politics and school calendars make this a high priority area for many lawmakers. Don't assume this is only about sports. The court's reasoning about whether sex in law includes gender identity could influence bathroom access, dress codes, single-sex programs, scholarship criteria, and anti-discrimination protections in K-12 and higher education. Employers, universities, and local governments will be watching.